Yes, I notice they appear as they say as before, isn't it?
Yes, court, please.
And of the accused persons, I hope everyone is there today. Yes. Today's business is for me to deliver my ruling on the continuation of the trial. And this is my ruling. It's a fairly short one. This ruling has been necessitated by difficulties that have arisen in connection with the conduct and continuation of the criminal trial in case number 06 of 2021, which commenced before me in December 2023. The trial commenced when the accused persons were called upon to plead to the charges that they are facing. During the plea taking, some of the accused entered pleas of not guilty, while others refused to plead to the charges, and the court entered not guilty pleas for them. The court discontinued the taking of pleas when accused 10 applied for the recusal of the presiding judge, and later accused 2, 3, and 6 applied for the reservation of certain questions of law to the Supreme Court. This court dismissed the recusal application and the subsequent application for leave to appeal that decision to the Supreme Court. The applicants petitioned the Chief Justice for leave to appeal, and that petition was dismissed by the Supreme Court. This court also dismissed the application for the reservation of questions of law to the Supreme Court. The applicants have indicated that they wish to appeal against the dismissal of that application. In addition to the 2 applications mentioned above and the decisions thereon, accused 2, 3, and 6, by way of 2 notices of motion, requested this court to give certain directions in terms of Rule 32 of the Rules of the High Court. They were unsuccessful. This court determined that the directions that they were seeking were in fact not directions at all, but a request for advice or a legal opinion from the court. The court thus declined to give any directions and struck off the 2 matters, the 2 motions from the roll. After the court struck off the applications for directions from the roll, it engaged the parties regarding the resumption or a continuation of the criminal trial. The responses of most of the accused persons and their legal representatives were not edifying. I detailed them below. The parties held some discussions concerning the resumption of trial among themselves. Thereafter, the state addressed a letter to the accused and their legal representatives to solicit their final position on dates of continuation of the criminal trial. Some responses were in writing and others not. At the hearing on 16 August 2024, the parties put their final positions to the court. The state's position is that it is ready to proceed with the trial. Accused 7, 8, and 9, and 4 entities they represent, all clients of Mr. Engelbrecht, are also ready to proceed with the trial. Mr. Engelbrecht stated that he is available on the following dates in September 2024, 2 to 6 September, 10 to 13 September, 18 to 20 September, and also 23 to 27 of September. He is also available from 10 to 11 and 15 to 18 October 2024 and the whole of December 2024. In 2025, he is available from 2 to 16 May and June to December 2025. The state opined that the position of Mr. Engelbrecht and his clients is reasonable. Mr. Siomunji, who represents accused 5 and 10 and 3 entities, stated that his diary is full and will only be available in February 2025 and from April 2025 to the end of the year. He also spoke on behalf of Mr. Bucas, accused 4 and 24's legal representative, and reported that Mr. Bucas is not available for the trial this year and will only be available from the beginning of 2025 and for the whole year. In respect of the 7 accused persons and entities represented by Mr. Siomunje and Mr. Bucas, it is the unavailability of their lawyers during the remaining period of 2024 that would stand in the way of the resumption of the criminal trial. The presently unrepresented accused, number 2, James Hatuikulipi, and entities he acts for, 17, 18, 19, 20, and 22, would want the trial to resume in January of 2026. Accused 3 and accused entity number 21 would want the trial to resume in August 2025. Accused 6 and his entities 15 and 16 would want the trial to resume in 9 months' time from now, which means he would want the trial to resume in May of 2025. Accused number 1, Ricardo Gustavo, and his entity accused 11 would want the trial to resume in April of 2025. As it is, of the 10 accused individuals, 6 are now legally represented and 4 are no longer so represented. Of those legally represented, 3 and their representatives are ready to proceed with the trial, at least regarding the completion of the plea-taking exercise. At the hearing on 16 August, and after the parties made their representations on the trial resumption date, I adjourned the proceedings to today, 27 August 2024, to make a ruling. I invited the parties to make further written submissions on the issue by 21 August 2024, if they so wished. The unrepresented accused did so, and so did the state. The representations were to further explain the position they took on the issue. Messrs. Gustavo, Shanghala, James Hatuikulipi, and Mwatelulo stated that they have several applications they would want to lodge with the High Court before the trial resumes. Mr. Gustavo said that whereas previously he had indicated that he would defend himself in person, he had since changed his mind and would want to be given an opportunity to seek legal representation of his choice. Until he has done so, he should not be compelled to plead to the remaining charges. In this connection, he said, and I quote, "I intend to bring a separate application on the back of Mulimwa's case to seek the state to fund a lawyer of my choice so that I may be afforded a fair trial per Article 12 of the Namibian Constitution. My circumstances are additionally unique in that my ability to fund for my own lawyer was taken away by the Supreme Court when they found in favor of the state after the appeal of my bail in December 2022, end of court." On 15 August, Messrs. Shanghala, J. Hatuikulipi, and Mwatelulo made a joint written presentation on applications they intend to bring to the High Court before the criminal trial may resume. They individually amplified on their joint presentations, and further submissions filed on 21 August 2024. They state that the taking of pleas on the remaining charges should be halted until they have lodged their several applications in the High Court. Implicit in their statement is that the trial must not resume until the applications they intend to lodge have been finalized. The intended proceedings or applications are the following. A petition to the Supreme Court relating to this court's decision on the application in terms of Section 319 of the Criminal Procedure Act 1977 on reservation of questions of law. B, an application that the trial should not be conducted in the courtroom where it is currently conducted. C, a review application to the Supreme Court in terms of Section 16 of the Supreme Court Act 1990, challenging the court's decision requiring unrepresented accused persons to plead to the charges. D, an application for the determination of the question whether this court is a competent court as envisaged under Article 12.1 of the Namibian Constitution. E, an application for the High Court to determine the legality of the use and admissibility of information by the Prosecutor General obtained through an unlawful investigation conducted by the Anti-Corruption Commission, which at the time was not empowered under Section 83 of the Prevention of Organized Crime Act, in the bail hearings and the framing of the indictment. F, an application for the High Court to determine the legality of the use and admissibility of information by the Prosecutor General not obtained and processed by the Anti-Corruption Commission in compliance with the Anti-Corruption Act, procedures, in particular Section 31 of that legislation, in the formulation of the indictment, at the bail hearings, and or intended use of such at the trial. G, an application for the High Court to determine the legality of the use and admissibility of information from foreign authorities not in compliance with the International Cooperation in Criminal Matters Act, number 9 of 2000, in the formulation of the indictment at the bail hearings and or their intended use at the trial. In his individual submission, Mr. Shanghala posed the question whether this court on its own motion cannot cause the state to pay legal representation for unregistered, to pay for legal representation for unrepresented accused persons. He asked the question, and I quote, "Is the court not empowered under its inherent power, read together with Article 5 of the Namibian Constitution as interpreted in the courts, to cause that the state pays for the legal representation of an unrepresented accused person, whether or not an application has been moved by such an unrepresented person? In the case of an accused who has not been successful in an application in terms of Section 26 of the Prevention of Organized Crime Act, is the trial court disabled from making an order in terms of Section 26 of the POCA itself to ensure that it ensures the enjoyment of a fair trial under Article 12 of the Namibian Constitution," end of quote. Mr. Hatuikulipi expressed similar sentiments on the exercise of the court's inherent powers and referred to the provisions of the International Covenant on Civil and Political Rights to buttress his point. He also stated that he was pursuing the options available to him after his application for the release of his property under a restraint order was rejected by the High Court. Mr. Gustavo stated that he intends to join his co-accused in pursuing a separate application, a separate case on the back of Mulima to seek the state to fund a lawyer of his choice, and also to launch a new application in terms of Section 26 of the Prevention of Organized Crime Act to put a lawyer of his choice into funds. He also said that he has already approached a lawyer to assist him with the intended applications on a pro bono basis. Mr. Mwatelulo said that he applied for legal aid and has been requested to provide further information about his circumstances. He has furnished the information and awaits the outcome of the application. He generally bemoaned the absence of legal representation for himself and urged this court not to proceed with the trial until he has secured such representation. The long and short stance of the unrepresented accused is that the criminal trial must not resume, even by plea taking, until they have resolved the issue of legal representation and obtained court determinations on several applications that they intend to bring to the courts. In its further submissions filed in response to my invitation, the court drew my attention to State versus Kuzachike, in which the court made certain salutary remarks in regard to legal practitioners who are unable to avail themselves on dates allocated for a trial, either because of prior commitments in other courts or simply because of their busy schedules. That case concerned counsel from South Africa who had been briefed for a trial but was unavailable on the trial date, and the accused applied for a postponement. Although the court granted a postponement as applied for in that case, because the foreign counsel had acted in good faith, it made observations that must guide all legal practitioners and are binding on them, such as that a legal practitioner who is not available on the trial date or dates must not accept the brief for that trial. In Namibia, as in South Africa and Zimbabwe, which has constitutional provisions similar to Article 12 of the Namibian Constitution, insistence on a specific counsel is not a right recognized as an absolute right. In this regard, the learned Judge Frank J. said the following, and I quote, "Had accused attorneys made an effort to look at authority, they would have realized that their attitude was suspect. Neither in South Africa nor Zimbabwe, which has a similar clause in its constitution, is an absolute right to insist on a specific counsel recognized. In this regard, see D. Anos versus Hale on Court Private Limited, and S versus Pawen and Pawen and another versus Acting Attorney General. The Zimbabwean authorities, so the judge said, also spell out the ambit of the said constitutional provision. I do not reiterate what is stated in the Zimbabwean cases, save to say that they set out the position correctly in my view," end of quote. The judge went also on to say, where counsel was briefed but was not available for a specific date or dates, the brief should not be accepted. Similarly, where counsel for one reason or another became unavailable after having been briefed, he should inform the instructing attorney so that arrangements could be made for alternative counsel. The learned judge in Kuzachike went on to say, and I quote, "It is unacceptable for an accused representative to come to court and hold a pistol at the presiding official's head to obtain a postponement. It cannot be tolerated that legal practitioners will always be entitled to gain a postponement by briefing a straw lawyer for the postponement only, and to point to the prejudice the accused will suffer if the matter is not postponed," end of quote. Now, as for disposition and the order I make, the criminal trial was slated to start on 2 October 23, almost 4 years from the time that the accused, from the time of the accused person's arrest and detention in custody. The accused have therefore been in pre-trial custody for a very long time. They have instituted and intend to institute many applications in the courts which have the unfortunate consequence of further delaying the continuation of the main trial. It is the accused's right to bring any application to court, but doing so does not necessarily mean their trial may not continue. It may well be that one or more of the applications will direct the trial to be halted, but until such a result has been secured, this court is entitled, in fact obliged, to proceed with the trial in the interests of the administration of justice. With reference to applications based on the Mwilima case, this court or other court would have to consider them when brought. It cannot be right for this court to foist legal representation or assistance upon an accused person when it is his right and within his power to make an application to the court for such assistance, but neglects to do so. Coming to the issue of the non-availability of counsel to represent the accused when reasonable dates for trial have been set by the court, the answer is provided by Kuzachike's case and the cited authorities. There is no absolute right to be represented by a specific legal practitioner. If the appointed legal practitioner is unavailable, he must decline the brief and pass it on to other practitioners. In a potentially long trial, such as the main criminal trial before me, the occasional non-availability of counsel must be accommodated, but without compromising the finalization of the trial within a reasonable time. It must be remembered that the stage at which the criminal trial is, there is no irreparable prejudice that will be occasioned to accused persons where they are called upon to plead to the remaining charges, more so if the plea is not a guilty one. To be remembered also is that of the 10 individuals facing charges, 3 have been ready to proceed with the trial. Their interest in the finalization of the case must be taken into account and balanced against the position of their colleagues who would want a long delay to the continuation of the trial. I find the position of accused 7, 8, and 9 and their representative to be eminently reasonable. The state also finds that position to be reasonable. To my mind, the issue of legal representation has been sufficiently addressed in the judgments that this court has handed down so far. This court must, for the time being, continue with the trial by taking pleas from the accused persons on the remaining charges. While the process is ongoing, the accused may file whatever applications they deem necessary to resolve the issues that they intend to bring to the courts. This court will continue to review the situation as the matter progresses with a view to accommodating legal practitioners through adjournments where merited. The order I make is therefore the following. A, generally speaking, the main criminal trial shall continue. B, the taking of pleas on the remaining charges shall resume on the following dates: 2 to 6 September 2024 and 10 to 13 September 2024. The timetable for the further continuation of the criminal trial will be agreed upon in consultation with the parties or directed by the court at the end of the period stated in the preceding paragraph B. Accused 1 to 9 are remanded in custody and are to be detained at the Vindo Correctional Facility and are warned to appear in court on 2 September 2024 at 10 o'clock. Accused 10 is on bail and bail is extended to 2 September 2024. That is the order.
Yes, the court.
Is the court please?
The court adjourns.